So Council Ferguson did contact Ms. Bauer and advised that he's running a tiny bit late. So perhaps, seeing how he took the courtesy to call in, we can wait for 30 seconds. Give him a chance to get here. What do you think? Maybe he'll...
He usually comes into the township, right?
Yes, he does.
All right, Council, it is 10:01. Council Ferguson says he's still about 6 minutes away. So what is the privy of the committee? Whatever the word is, what is the direction?
Have we got quorum?
Of course we do, but Council Ferguson called in and said he would be a little late. Do you want to wait 5 minutes? Are we okay with that?
Well, actually, I don't want the meeting to run over noon, so if we've got quorum, we should just proceed. He can join when he gets here.
Okay, I don't anticipate the meeting going past noon because there's only the one item on it, but I know that we're going to start off with a presentation from staff that might be of benefit to Council Ferguson. If it's okay with you, we'll wait till 10:05. Then we can go get another cup of iced coffee. And we'll start the meeting at 10:05.
Bob,
Sounds good.
Can you hear me?
Yes, David.
Hey,
Okay.
David.
Hi,
How are you
guys.
doing over there? How are you feeling? Good? You look great.
I never look great.
Oh, yeah.
David, you look great. We're happy you're back.
You look great.
Okay, thanks, you guys. Okay, I'll just wait.
Looks like you're on your front porch too, are you?
Yeah, I actually am. Yep.
Nice.
Nana has some tissue.
All right, it's 10:02. We'll wait till 10:05, Council. Okay, well. It's 10:06, so maybe you want to start our engines? Okay. Thanks for your patience, Councilor. Hopefully he'll show up any second now, but at least it's given them a bit more time. So I'd like to call the meeting to order, the Council Priorities Committee for this, the 21st day of June, which is the first day of summer. And I guess I would start off by saying, I'd like to start by acknowledging that we are on the unceded traditional territories of the Kwantlen, Katzie, Semiahmoo, and Matsqui First Nations. And I'd like to call the meeting to order and ask for a motion to approve and receive the agenda items. Councilor Arneson and Councilor Whitmarsh, all in favor? Opposed? That's carried. And this item was forwarded to this committee meeting at the May 10th regular council meeting. And for some background, Mr. Bakken, we perhaps ask for a brief presentation of what we're going to be discussing, the subject matter, and we can take it from there. You okay with that, Mr. Bakken?
Yes, Mr. Chair, thank you. And just to clarify somewhat, as it's a CPC meeting, under the terms of reference, we're here to, I guess, clarify and expand. We're not to start launching presentations to influence council right away. That has to be requested by council. So this will be a description and an attempt to focus where we're at with the issue. Also, a special recognition of Councilor Davis. He's made it under some adverse circumstances. Now, Councilor Davis, I understand you have a number of children. So we also understand that you're alleging this was a medical procedure. But if you are in distress due to family matters, if you blink your eyes in Morse code, we can send help. So be aware that's available to you if we need to do so. It's just interesting where the injury actually occurred, given the size of your family. Having a similar sized family, I can relate. So be careful out there. Moving forward, the package before you was actually developed for council on the basis of the discussion of the referral, and this was referred to discuss the concept of land lifts. The concept is really because there's been a change in the underlying designation and potentially zoning of this property. When I say designation, it's OCT designation. It would be appropriate to have a discussion of land lifts. Sometimes they are referred to as community amenity contributions. Sometimes they're referred to as community benefits. Sometimes they're referred to as just donations or matters of that nature. All have the same root. All are somewhat different. We do have a CAC regime, community amenity contribution regime. So that we have discussed previously. That is something for which industrial lands or changes of this nature are not contemplated. And frankly, it's because they don't happen very often, but it's something that certainly can be dealt with going forward. And that leads us to the discussion then of, is it appropriate then for there to be something such as a land lift or community benefit? That's something council will have to discuss. There's another issue though embedded in the documentation that I'll try to actually deal with for clarity purposes. And that is the stage of the process, or the stage of the process for which the land is at in the development process. Specifically, what we see here is that there are 8 lots. The 8 lots were approved for exclusion by the Agricultural Land Commission with the condition that they all be processed, I guess, concurrently as one application, as one grouping. What you're seeing here then in some of the communications from the applicants are that there is a reconsideration application being made to the Agricultural Land Commission so that they will actually lift that requirement. So the land is in the Agricultural Land Reserve. It's been approved for removal. There's a subject condition. The subject condition is it all be processed at the same time. There's been a reconsideration application filed so that it can be dealt with in pieces or parts. And it looks like the suggestion is that there would be 6 lots as one grouping and 2 lots as another. There is a history to that we need not get into among the parties. There is also different views in terms of what that means in terms of going forward. I think there is a lot of common ground among the applicants in terms of who has contracts for what, who is speaking for who are the agents of who, but there is this outstanding issue that there's a Agricultural Land Commission reconsideration application still remaining outstanding that has yet to be processed, or is perhaps better said to be being in the process, but not yet fully processed. And as such, it's where they're focusing. It is clear that one of the applicant that has the 6 properties under contract is prepared to advance it, taking into account all 8 properties, but making sure that the OCP amendment and the Metro Vancouver Regional Growth Strategy amendment is actually considered holistically. The other party is suggesting that it's premature. I'm not sure they object to it being considered holistically, but they may feel there's a need for additional consultation. They may feel there's a need for a wait or a delay until the ALC application, reconsideration application is completed. Council in their purview in this circumstance can consider those issues, but the original purpose was to discuss the lift, if you will, or the community benefit, and to come back with a position on that in regards to this application, so that it could be processed for first and second reading. Again, keeping in mind that the additional factor is this Agricultural Land Commission reconsideration application in the background. So, Mr. Chair, I hope that provides you with a start. We can certainly delve further, and we have staff available to dig into it in more detail.
Okay, well, thanks for that, Mr. Buchan. And there is a hand up, but just before we go there, so when you're talking about land lifts, which is really the subject matter of this meeting, how does that pertain to this particular application? You're saying that this is council's consideration, so when it comes back to council after this meeting, does council have the ability to put some additional conditions on this rezoning in terms of a land lift?
So, Mr. Chair, the council must be somewhat cautious because we've already described that one of the categories of land lift, as we'll call it, the community amenity contribution, does not pertain to these properties. If we were to try to apply that, it cannot be done or ought not to be done retroactively. However, here, because it has not yet had first and second reading, if there was to be either a change in the regulatory structure, or if there was to be a negotiated, position of the township, it would be in order then to have that process, that being either they'll change the regulatory structure or the negotiations occur prior to the granting of first and second reading. That would be the process that would be appropriate. Otherwise, it could be suggested it's going to be retroactive. You do raise a good point, though, because both parties in their submissions do reference the challenges such an approach would be. Just to be fair to them, they're saying that these lands were acquired on the cost basis of it being approved for exclusion. So as a consequence, prices were paid or sums were agreed to with the owners based on the regulatory scheme that was in place, and they point out what value they attributed to these properties and what they paid, either outright or by way contracts where there's significant deposits in place. So the applicants are of the same view, I believe, and that is that if council wishes to embark upon this process in changing its regulatory scheme, they would argue that we ought not to delay this application and put that scheme into place, or ought not to negotiate with them. Instead, we should process this and put the scheme in place for later applications where these situations may occur.
All right, well, thank you for that. Councilor Rick, do you have your hand up? Would you like to have special clarification from Mr. Buchan?
Yes, I do. Thank you. First of all, it seems quite clear to me that in 27A of the ALC decision, which is page 43 of B1, the properties are dealt with together. All properties be removed from the ALR at the same time to create a continuous ALR boundary. So why on earth would 6 properties be able to come forward to council without the agreement of the other 2 properties when the ALC has made that specific requirement? Like, I'm not understanding why this matter even got to council, because it's in contravention of the ALC requirement. So that's my first question. My second question, I want to talk about the stormwater management plan for that area. For Gloucester, we know that they have not got one. We know that because it's been problematic several times over the past few years, and that they just squeaked under in total landmass from avoiding having to do an integrated stormwater management plan. It seems to me that this ALC decision is also quite clear in its requirement around drainage, which I interpret as meaning a stormwater management plan. So I would like to know if we can now proceed with a complete stormwater management plan as part of this rezoning, and if the cost of that plan can be taken from some sort of a community benefit. And I also, or community benefit charge as opposed to community amenity charge. And that brings me to my third question, which is what are the other additional amenities or upgrades that infrastructure in the area is going to require? For example, do we need to replace or contribute to the replacement of the Highway 1 overpass there, 264th? Do we need to widen roads, etc.? And can those additional amenities be included as part of a community benefit amenity charge? And if we did put a community benefit amenity charge in place to cover industrial lands, can it be made retroactive? Because it seems to me we've got some other parcels of industrial lands coming forward to council's table. So those are my three questions. Thank you.
Mr. Backen, did you catch all that then?
I think so, Mr. Chair. I'll give it a whirl, and we'll ask Mr. Seppi to join in, particularly as to the stormwater management plan and whatnot. I'll speak to the overall scheme and then about the ALC process, and Mr. Seppi can perhaps dive into some of the stormwater matters and correct and clarify anything that I've said. Kind of in reverse order then, the caution would be in terms of applying anything retroactively. It's very challenging. There may be some ways to do it, but it's very, very difficult under administrative law principles to actually try to do something in a retroactive fashion.
Okay, if we can't do it retroactively, sorry, Mr. Backen, if we can't do it retroactively, can we put off this application until it's in place?
Well, that's where I was going, reminding council that this application is not yet received first and second reading. There are provisions one could argue that would apply for applying it, I guess, at this point. There are cautions even at that, though, because when the application was submitted, there was a regulatory scheme. So between the time of submission and first and second reading, there is certainly more latitude, but those procedural fairness rules still apply. That being said, I think where you're headed, though, can also be achieved, at least at the discussion stage, by having negotiations to see if the applicants are prepared to offer a community benefit. That's not really a charge or levy we put into place, but we deal with them to see if they're prepared to make any community benefits given the nature of their application. And that residual negotiated approach can exist in all applications that are between, the application stage and the first and second reading stage until a new regulatory scheme is actually put in place. In the long term, it's much better to have the regulatory scheme in place because then there's certainty in terms of what those fees and charges would actually look like. To the Agricultural Land Commission issue, the reason why it's before council is the applicant with the 6 properties elected to pursue it, and it's understandable because they wanted to make sure this ran on a certain time frame and concurrently. To do so, they actually ensured that the application at the OCP level and the Metro Vancouver Regional Growth Strategy level met all the conditions for all 8 properties. So effectively, they advanced them as 8 properties at that higher stage. As the applicant
but legally, pointed out, Mr. Backen, legally, how can they do that if the owners of the property weren't involved?
Let Mr. Backen finish before you interact, if that's okay. Thank you. The rest of council.
Thank you, Mr. Chair. Now, because it's an OCP and Metro Vancouver Regional Growth Strategy amendment, any applicant can request that they proceed on a grander area. As the other applicant is suggesting, and I think they concur they wish to get to that level, but they think they should be able to be doing that process themselves, and that relates back to the approval you pointed out. But the fine point is that while one party cannot actually make a submission to affect other parties' rezonings, it can be suggested that they are trying to amend an OCP to take into account the other properties that may be of concern, provided those properties are for the benefit of the overall grouping, and provided that usually provided the other party is actually in agreement with that, as you're saying. Do they have to be in agreement? No, it's a bit like a local area service by analogy. They don't have to be. and this party is pointing out that perhaps it's premature and that they should be. And that's something the council can deliberate upon if they so choose. Keeping in mind the lift issue is what our focus is, because the lift issue or community benefit would apply to all of the properties, all 8 of the properties, and as the way this application has been structured. Now, Mr. Sefi, as to the stormwater and perhaps the benefit being the plan itself, can you comment?
Yes, thank you, Mr. Chair. The typical process for the Township of Langley is for technical issues, including primarily stormwater management, but also road design, intersection improvements, storm sewer, sanitary sewer, water network, is to consider the catchment, if you will, as opposed to a single application. And that remains the same with this area. And what I mean by that is then to clarify, regardless of the size of the application, whether it's for 6 or 2 or 1 or all of the area that has been conditionally approved by the ALC, the requirement will be the same in that the applicant will be required to address the stormwater management needs of the entirety of that particular area that's been subject to the ALC approval and requires the OCP amendment. So I hope that answers the question. We don't know specifically what the requirements are at this stage. That is typically something that we have a good idea at a high level, but really we'll get down to the detailed stage after council has considered it, past the public hearing and 3rd reading. That's when the time comes for the applicant to engage the qualified professionals at a more detailed level and determine what the actual needs are.
Okay, thank you for that. Now, before you speak again, Councillor Richter, and maybe I can get some help from the rest of council and clarification from Mr. Backen, because you've said a couple of times that the reason this was referred to this process committee, the policy committee, was to discuss the concept of community amenities in applications such as this. So are we, Mr. Backen, we'll need your advice on, are we supposed to be discussing the specifics of this application or the whole concept of applications coming forward of this nature? Because I want to be careful that we don't put ourselves in a position of that we might maybe regretful. Mayor Rose, maybe you can help out here. I don't know why I get all the tricky meetings to chair, but I think, Mr. Backen, you were trying to say that we need to talk conceptually and that we might want to refrain from the specific details of this. Is that what I thought I heard you say before Councilor Richter speaks again?
Thank you, Mr. Chair. Partially correct, and you're quite correct. This is very complicated because of the nature of the referral. And I was just going to begin with what Mr. Sefi said, because there was a piece that I still think needs to be addressed, which is Mr. Sefi is quite correct as to the technical management of the stormwater plan itself. I believe, though, here the second part of the question for Mr. Sefi to consider while I answer your question is, but what about an overall integrated stormwater management plan for the area? Could that be a community benefit that we would seek from the applicants, or is that something that should be done prior to any applications being considered? So I'll leave that to come back to him, because I think that comes back to this nature of community benefits. As to the application itself, it is, I guess, primarily here to deal with this conceptual matter. It gets a bit complicated because, of course, the conceptual matter arose in the context of a specific application. So as a consequence, it is relevant to discuss the specific application because it will be directly impacted by council's decision. And I think it would be unwise to actually ignore that application. But that being said, we should not be looking at trying to predetermine the merits of the application for first and second reading, but rather the merits of applying a policy change or discussion as to what this application could trigger on the grander scale. So I hope that actually helps. They are relevant, but our focus should be on the issue of the community benefit.
Okay, that does help somewhat. And I guess that when it comes back to council, maybe a more appropriate time or whatever decision this committee makes and what form it comes back to council to discuss specifics. Here we're having just a roundtable discussion about the issue, but I would feel that we should be careful not to be too specific at this meeting, but rather formulate some action paths for council. Councilor Richter's hands are up, and then Councilor Richter.
Yeah, well, I didn't finish my first time around, Mr. Acting Mayor, because I had additional questions. So I'd like to deal with my additional questions, please.
So you're gonna go over, well, we have Council Woodward next.
Excuse me, Mr. Mayor, I still have the floor. I didn't give it up.
No, you gave 3 questions and you sat back, and now we tried to answer, staff tried to.
Okay, you know what? This form of meeting is not working, and your form of chairmanship is not working for this form of meeting. Stop being so directive.
You know
This
what?
is a discussion forum.
May I step in, please?
Well,
Council,
you were going to anyway.
Yeah.
Council Woodward, are you gonna speak or not? Because you have your hand up.
Yeah, I'm not sure if I have the floor, Mr. Chair. I mean,
You have-
maybe Councilor Richter can just text me your questions and I'll ask them then, if that's how you're gonna chair the meeting.
Actually, Council Richter already spent quite a bit of time asking questions. You put your hand up, you're next. Then we'll go back.
Could I raise a point of order, Mr.
Absolutely.
Chair? I just want to reiterate, we should have a conversation here and we should respect the chair. That's all I'm saying. And he's certainly not going to prohibit anyone from speaking. And so let's just have this roundtable. We have a great opportunity to get together as a council. I'd ask that, we respect the chair. Thank you.
Well, I'm gonna take offense to that. I'm not disrespecting the chair. I mean, I don't know why anybody would infer that and then of course want a civil discussion at the same time. I mean, I just don't want to, if Councilor Richter has questions, why are we moving on to me? That's all I said.
Because we're taking turns, even though we're allowed to speak more than once, I suppose. I don't know what the exact policy says. We are more flexible in the amount of times you can speak, but I'm going to try and share the meeting with all of council, okay? So you're next, and then if Councilor Richter needs to go, she can certainly ask more questions. We've got a couple hours, and then Councilor Arneson would like to speak as well. So, Councilor Woodward, you have the floor now. Do you wish to continue, or would you like to give it up?
Okay. No, I think I was going to agree with actually Mayor Froese. This is supposed to be a bit more cordial and more of a discussion. I mean, I don't know why it's descended down into like the first 10 minutes, you trying to prevent conversation. So I wanted to remind.
Wait a minute, I'll take exception to that comment. I'm not preventing anything. You have the floor now. Let's not waste any more time. Please use the floor.
Okay, so if I could make my point, I would have say why I've reached that conclusion. So, for example, in the original motion referring to this committee was, and I'll just read it out, the application numbered 100209 be referred to the council process committee for a more complete, unfettered discussion and debate. So I think, this isn't just discussing some general policy objective. It was specifically to discuss this application. And for me, it's implications in an unfettered way. That was the motion. So I guess I'm trying to get some clarification on why you're trying to restrict the discussion.
Councilor Woodward, please don't continue to repeat something that is not true. Nobody is trying to stop any conversation. We take turns. Your turn.
I would like to have the unfettered debate on this issue because I think it's pretty important. You're going to continue to cut me off, Councilor Long. I'm just going to stop talking every time you do that.
Okay, Councilor Arneson, would you like to speak?
Okay, thanks.
Thank you. Through the chair to Mr. Backen, I understand that there is some discussion to be had, and I thank you for your clarification with respect to trying to figure out which elements potentially should receive more focus today. Not that we can't talk about the overall application because, I see this as being very interwoven with what the original intention was to put this to this meeting. But I do have a question of clarification. So further to just the element, if we're strictly talking about the imposition of any kind of new fee, I would want to know, have we sought a legal opinion as to whether or not whatever we decide to call this without any process, I'm going to call it the statutory due process, what that would look like? Because I get the feeling, and further to our actual obligation, is to ensure that the township does not get into legal challenges with respect to applications. So I just want my question to be focused on the fact that generally speaking, what we have as a result of our CAC policy in the first place is engagement, a process of dealing with that, then going through the steps. Now, if you have something that's an intervening and already begun process, I would want to know what is the legal ramifications if we decide that we want to start discussing and potentially implementing this type of new fee. Thank you.
Mr. Backen or Mr. Safety, please,
Yes.
can you respond?
Mr. Chair, thank you. So, Councillor Arneson, thank you. I think you're beginning to grasp the complexity as to the application versus the policy issue. You're quite right that the matter, as was referenced, was referred for a further discussion explanation. I think it is appropriate then to engage that as to the application itself and to understand the underlying facts that are there and to have a discussion. But again, because it's a matter, an application that ultimately will be adjudicated upon for first and second reading, to keep in mind that that's where a lot of the policy, a lot of the discussion needs to also be focused. So we're not seen to be prejudging the application, but clarifying and getting explanations. As to the actual issue of the legal opinion on the process, we do not have a specific legal opinion, I don't believe, on the referral from the meeting to here, but we can talk about it in generalities in terms of previous, analysis with legal counsel on similar issues has indicated that if one is to have a CAC type scheme, it needs to be effectively entrenched in a bylaw, because there has to be that certainty and that knowledge and that fair practice in terms of what's going forward. That doesn't preclude, however, the council from negotiating. So again, without a bylaw, but directing staff to negotiate a community benefit. The current trend would be to move away from that negotiated approach to go to a more regulatory scheme that would be very clear and transparent going forward. And I think that's the overall direction we're headed to, at least with residential properties. The challenge we face with this application is it's quite unusual, at least in the last 25 years. We can't really think of any where we've actually had an OCP change and the property is going from rural to industrial. That's very rare to occur and does lead to very many questions and debate in terms of, well, if there is to be a lift in the land value, should that be analyzed? And can any portion of that through effectively, unless there's a regulatory scheme, which there is not, then through a negotiated process to obtain that, to which the applicants would then say, but wait, the land lift in many instances here has already been provided to the vendors of the property. So there was, again, from their perspective, they're simply pointing out that that has occurred. That need not impede the township per se. It's just a factual reality, and I think it's worth noting that their position is that effectively any room for that lift or benefit in some ways has been appropriated to the property owners because of the designation. That was through their choices, though, not through any regulatory scheme we had where we considered the property being future industrial.
All right, then we have Councillor Kuntz. So this, maybe I could state something here to the entire committee. This is an unfettered discussion, which means I'm taking note of who's speaking in what order and allowing those who have spoken to speak first, and then we'll just continue to go around and around. That's the same way we do it at public hearings. It's the same way I believe that the policy allows for meetings, although this doesn't include people speaking more than once. So if there's no objection to that, that is the policy or the way I'm going to conduct the meeting. I'm not trying to stop anybody from speaking, but in all fairness, to all of us, that's the way I'm going to try and do it. So, Councillor Kuntz, you're next.
Hey, thank you, Mr. Chair. Through you to staff, are there any examples where we've negotiated a community benefit charge or anything like this in the past that that we can use as an example?
Mr. Chair, prior to the formulation of the CAC policies, there were situations where the community benefits, Mr. Seffi may be able to recall a couple. One came to mind that's really an illustration, but doesn't really apply directly, was the pipeline, the Trans-Canada pipeline. Through a policy approach, they negotiated community benefit agreements with many of the impacted municipalities. Again, there was no regulatory scheme calling for it, but they went through that process to deal with some of the benefits that might deal with some of the jurisdictions that would be having the pipeline going through their properties, and tried to make sure there was some level of benefit occurring. So that may be one sort of illustration. Mr. Seffi, do you have any more direct in terms of the older approach of negotiated community benefits?
Thank you, Mr. Back and Mr. Chair. Nothing specific comes to mind in terms of the historic approach prior to Council's adoption of the current very formal CAC policy process. As Council has been advised in the past, as part of the adoption of the said CAC policy, it's not like we didn't have a formal community amenity contribution policy. They were enshrined within our various neighborhood plans. So primarily related to greenways and open spaces. But through the CAC policy adopted more recently, we have been able to obtain contributions towards other community needs. And I guess if I were to sort of, think really hard in terms of what we used to do beyond what was required as part of the neighborhood plan, the various neighborhood plans, if in fact the application was pushing the envelope a little bit and also at the same time met some pretty fundamental planning parameters, I would have to think about what has council told us in terms of vision that they would like to have. As an example, an overpass, a pedestrian overpass, whether it's in Murrayville, whether it's in Willoughby, or whether it's in Fort Langley. Those kind of messages that we get from council then form the basis of staff negotiating with applicants and trying to, based on the size and scope of the application, acquire some kind of a contribution, or in fact, if the application is significant, the entirety of the contribution. That said, there have also been cases where applicants have provided playground facilities. The applicants have provided, passes to rec centers for the residents. So those have been examples of what has been negotiated and deemed appropriate by council.
All right.
Yeah, I just wanted to add one more thing. So at some point at the end of this discussion, is it possible that we could, have that, maybe have this referred to staff to have a look at what that might look like, so that, if the application or the applicants would be amenable to having a discussion about that. I mean, I understand that, these are employment lands and we get an incredible community benefit just because they will at some point become employment lands. But, I'm also willing to just, have a look at, some options here. So that was just my question to staff.
Mr. Back, and I think you said that a couple of times, but can you verify that would be an appropriate approach, or one approach that we could use?
Yes, Mr. Chair, with one clarification, it would be the committee making a recommendation back to council that would embark upon those discussions. So in the illustration that was given, it'd be referred to staff to approach the applicants to discuss the potential community benefits they're providing to the community and anything they could actually enhance or provide. But that would come from the council table, would be a recommendation from here going forward, if that's what the recommendation was.
So let's be clear about that, Mr. Council. So we can talk about that at this meeting, and we can even have a resolution, I suppose, but nothing would happen until it came back to council. Is that how the procedure would be? That's the appropriate process, as this is a committee of the whole until it's actually a council motion. It's really something we shouldn't be acting upon unless there's some urgency is provided by unanimous consent or by the chair. That's scary. Okay, Councilor Whitmarsh, you're next.
Yes, thanks, Chair Long. I had a question through to staff. When we put the CAC program together, I think that it was approved by us in 2019, and I sort of remember us talking about it being a plan that was for residential properties and to provide a community benefit for the increased residential growth that was happening. And but we didn't include industrial properties. And I'm wondering if maybe staff could remind us why it was that we did not include industrial properties. I'm wondering if it's because it just rarely happens, or is there, or was there another reason why we would not include industrial properties from the CACs? I mean, CACs was about growth. It was about developing more residents living in an area, and so needing to provide benefit. But industrial lands don't provide for residents, they do provide work and employment for people. But I'm wondering, just from staff's perspective, if you can recall the conversation as to why we might not have included industrial at the time.
And Council Whitmarsh, would you mind if staff would also talk about commercial lands?
Sure, industrial and commercial, both of them would be fine, yeah.
So, Mr. Chair, I don't know if Mr. Backen wishes to provide additional comments, but I'll start. So there are three, I guess, matters that council should keep in mind. One has been discussed, and that is the benefit that non-residential lands provide in terms of employment generating. So those are uses that historically have been determined to be beneficial to a community, to developing a complete community. The fact that, we have had a long-standing goal in township of having one job per person in the workforce for over 20 years talks to that, the need for employment lands. And as I said, that's been discussed by a couple of members of council already. The second part is, I guess, the part that, generally speaking, employment lands, non-residential lands, do not drive the need for amenities. Now, I mean, that's arguable, but typically, whether it's open space, park space, whether it's recreation facilities, all of these things are generally, for the most part, driven by residential lands. And that leads to the third part, which is quite clear. It's a fundamental principle of any provincially sanctioned regime. And that is what's been referred to as the concept of nexus, the doctrine of nexus, which is essentially there needs to be a connection between what is being charged and what is being the basis of what's being charged. So if there's no direct connection between the industrial lands or commercial lands driving the need for, say, a recreational facility or any other amenity, then really it's difficult and challenging to make a case as to why they should make that connection. So those were really the reasons why it was excluded, or the concept of non-residential contributing to CACs was not included as part of the discussions back a few years ago. Now, that said, just as a quick reminder for council, more recently, I forget the exact date, forgive me, but council did direct staff to take a look at official community plan amendments. Now, this is, again, not to be confused with non-residential, but rather beyond the CACs, what should the Township of Langley obtain as part of community plan amendment applications? That is something that staff is looking at doing and hopes to be able to bring to council before the summer break, before August. Then what happened subsequent to that was council also directed staff to take a look at non-residential impact. So remember, two different things. One is OCP amendments, the other one is non-residential. Now we are going to combine the two together and bring forward, as I said, a more comprehensive report with options to council to consider that discusses the original referral to staff, which was OCP amendments, primarily not related to non-residential, but in addition, rezoning and OCP amendments for non-residential. I hope that's clear.
That's very helpful. That's good. That's good for now. I'll think of have some other questions, but maybe later. Thank you.
Thank you very much. And Councilor Davis?
Yes, thank you very much. I was just wondering, I'm a little confused because this hasn't come to council yet. And we are, the owners still have time to be involved in what Mr. Backham said, like a land lift or a contribution or whatever you wanted to call it. And that kind of puts us in a bit of puts us in a position where, now it's like, us against them. I don't like to say it quite so simply put, but that's more of a comment. I'm concerned about, as Councillor Arneson said, is it legal for us to do this when we don't we should have this in place before this comes to council, because that can be issues. It's like all of a sudden now we get it. Well, actually, no, because we don't have a policy, and I'm taking it that this is kind of a one-off. Like there's always just a one-off that we don't get them much, so it's like we have to look at it and prepare for it. That's what I'm concerned about. But I am concerned though. Do we get detail with this? And I know Mr. Backer explained it, and since the conversation from him explaining it, do we get detail on this application, or is this something that we're looking like more like for policy? Because I'm just I have other questions, and stormwater management. What about the road? I'm sure that those would all fit in, but I'm just concerned about us. It hasn't come to council yet, and it's going to, and it's here to talk about. So I don't want to get too detailed. So maybe just brief me on that again.
Yeah, Council, Mr. Backer, can you, the comment that it hasn't come to council did come to council, and it's in a deferred state at the moment, right? It did come to council. Mr. Backer, maybe you could expand again for us. What is the status of this application?
Thank you, Mr. Chair. Yes, it was on the agenda last meeting for first and second reading. As has been referenced, that was referred to the CPC meeting, and there was some talk as to which CPC meeting it ended up here for discussion of the application and the land lift. I believe the primary impetus was the discussion of the lift. However, as has been referenced quite correctly, it was the application for the discussion of land lift. By that terminology, the use of the application does give council the ability to ask a broad range of questions about the application, as with references, is to better understand it, to use this opportunity to deal with any issues that may come up collaterally, such as transportation, stormwater. One can understand, I think, some of the costs that the application would be experiencing in the context of trying to figure out if there is room for a community benefit discussion, negotiation, whatnot. Just to emphasize as well that in the old approach and the approach we're talking about at this moment, it is really not a prescribed tariff of CACs or fees, because that scheme is not into place. It's really going to the applicants and saying, gee, would you like to benefit the community? Would you like to volunteer something? So it's that approach that would be in place. And the answer may be no, look at our application as it is, thank you very much. And then council could adjudicate upon that when they consider it for first and second reading.
Okay, thank you.
If I could just ask a question that I haven't actually spoken, is that when Mr. Safi, you answered Council Whitmar's question about the application of benefits, and you mentioned the word nexus, which is a great one. I guess nexus meaning a connection, an absolute connection. Would the stormwater management plan potentially qualify as that type of a connection?
Yes, thank you, Mr. Chair. That would, but let me, I guess, be a bit more definitive, because I think what Mr. Backham was referencing has been discussions that have been had with respect to the area to the east. Now, one distinction I need to make here is for clarity: the subject area, the area that contains the 8 lots that have been recently conditionally approved by the Land Commission. They are in a different catchment, different watershed than the area to the east. This subject area drains northwest towards Salmon River. So when I was speaking about a stormwater management plan, I was speaking about a smaller stormwater management plan, not the larger integrated stormwater management plan, which is watershed-based, not catchment-based. Now, so I guess to clarify again, what I was saying earlier was an applicant needs to address stormwater management requirements, which may include provision of a detention pond or other ways of dealing with the impact of the development on the catchment holistically for the entire catchment. If we can anticipate, reasonably speaking, what areas can be developed. Now, in this case, we can reasonably expect that whether it's 1, 2, or 6, as I said, of the parcels proceeding, then they need to address the needs of all 8 lots together, which is consistent with the Land Commission's condition that Councilor Richter at the beginning of this discussion was referencing. And then subsequently, in response to Mr. Backen's question or comments about integrated stormwater management planning processes, there's not one needed for this area because, as has been discussed with Council historically, there's a provincial requirement for a certain percentage of a watershed area to be impervious, and I believe that's 20%. And at best, this area it goes through Summer River. Obviously, is Summer River area, Summer River uplands, which is not slated for development, and then ultimately Fort Langley, and actually extends upstream to Abbotsford. So all of that area, even if it was to develop, it would still not reach, close to the 20% impervious nature. And as such, there's no need, nor is there, a plan, unless otherwise directed by council, because it's really not practical and not beneficial to do a larger integrated stormwater management plan.
Okay, thank you for that. Now, Councilor Ferguson, you are up, and I'm glad you made it. Hope your car is still running.
I made it, and the car's running. One of the cars is running. Okay, so, well, wow. Welcome, everybody. Thank you, Chair Long. I've heard some discussion, some questions, an agricultural land reserve application a number of years ago that was surprisingly awarded to the applicant in the area, knowing others have applied both in Abbotsford and also within the area as well that didn't pass. So this one has gone through. But there were some, as Councillor Richter had indicated, some questions or requirements that the Land Commission wanted. That also was something that I believe, and don't profess to be an expert in the area, that it's 8 out of 8, not 6 out of 8. So we're looking at that. Subsequently, we've got a letter from the applicant, which we're discussing today, and we got a letter from the other 2 lots. We've got, as we all know, it's 8 lots, but the 6 are being discussed. The other 2 lots, the other person to understand what's going on. We also know ourselves involved the future of industrial lands, both a Metro report in the past and the provincial government looking at the need for industrial lands. Perhaps people jumping in on it. I don't know. I don't even know what the province is going to do. I know Metro Vancouver is interested in it, so this could be a reason for those who apply for the regional growth plan may indeed get it passed. I don't know that either. That would be up to the board members and the committee of Metro Vancouver. We also have a say as to what we're going to do as well. So, I mean, it's funny, a lot of things are happening. But and then Mr. Safey had some comments regarding a report coming forward, either what we would do with the community contributions, not necessarily a CAC, but something that a land use person. He also talked about watershed, environment, stormwater management plan, the whole number of things that come up. But I have a simple question to staff right now today. I just been pondering this. Who owns that land, those 6 parcels?
Mr. Chair, with Mr. Backen's silence, I take it as my cue to provide some comments. The correct answer is I don't know, Mr. Chair, but we do know that the applicant is entitled legally to make application for not just OCP amendment, but also for rezoning. So in other words, they have an interest. They have either some kind of a contract that may be subject to other conditions, financial arrangements. We don't know, but all I can say is that I can look it up and I can provide council with the information as soon as possible. But at this point, I'm not aware of the actual ownership. Some of them may have already exchanged ownership, some of the 8, and some may remain under the name of the historic owners, with the applicants having an interest and as such being able to apply on behalf of the owners.
Now, Mr. Safety, thank you, but I know that there's nothing, no surprise to any council members here, certainly not myself, that someone that would purchase a property subject to, that means me, if I can go down and buy a 400 square foot place for me to live in and my family up in Aldergrove, and subject to me getting financing. In other words, I wouldn't get title of that 400 square foot place that I would live in, so, that I could afford, subject to financing. And if I can't get the financing, then I don't own the property. I guess I'm not a lawyer, but I'm really surprised right now when we talk about land lifts and who owns it and who's going to shake. I would think, and I don't know because these are all things we need to discuss and the public to know. I would think that if the property owner hasn't quite sold it yet, then it would be up to some individual somewhere along the line, the owner, to take that lift, if there was a huge lift, if there was. And that's, economists would say that and others. Now, how that would come about, I don't know, but it's important for us to know who owns that property. And that's I'll have other questions down further during this meeting, but that's an important question for me. Thank you.
Mr. Chair, if I could just add something to Mr. Seffi's answer. Of the 8 titles, 2 have been conveyed, and those are the 2 that remain with the numbered company that we know they have outright ownership. I believe you're focusing on the 6 properties that are, I guess I'd put it this way, we can certainly identify who the owners are, but I believe they are the same parties as were the applicants to the Agricultural Land Commission originally, and perhaps for the reconsideration. What we see here is...
That's so important to me, Mr. Backen, because I really get messages or ideas from folks saying that the applicant has bought the property. But that's important for me to know who legally owns it. And you guys might have to dig on that, but I really would like to. That's very important to me. It's also important to me during this discussion. Thank you.
Mr. Seffi can likely circulate the titles in due course. They may be available to him even later in the meeting. We will see. My point was, though, that is only a piece of the puzzle, I suppose, because while they may actually be in the original parties' names, we understand through the representations contained in the package today that there are contracts in place with Con West to acquire these properties. 5 they reference as being under contract, and 1 they reference as being effectively, and I'm using my language, not theirs, subject to a joint venture agreement. I understand that those contracts are firm, and I understand that there's significant deposits that have been made. So the prospect of what you're suggesting is that, is there ability between the parties then to renegotiate based on a firm contract? That we do not know. There may or there may not be. It depends entirely on the relationship of the parties. If I was a vendor, I may take a very firm position if it's truly a firm contract, but I'd have to weigh that, I guess, vis-a-vis what would happen if there was a new regulatory scheme put into place that could impact me, that I would be subject to in a subsequent sale. I'm just saying that this is a very, unfortunately, complicated legal issue in terms of we do not know what the language of those contracts say, nor would we ordinarily. We would simply have the landowners provide us with confirmation of the authorization of the development entity, Con West, to make the applications based on their I guess, situation or their status within the redevelopment process themselves.
I mean, just to finish up, there's very important to me, Mr. Backen. It's very important to me. I know you've said it seems complicated, but I don't think it's that complicated. Maybe I'm not going to pick up the phone and phone up the lawyer for the 400 square foot place in Aldergrove. But I think if I can't get the funding for that place in Aldergrove through the bank, that contract is void. But maybe I got to talk to maybe I do own it. I don't know.
Mr. Chair, just to clarify that one point, because I understand where you're going. Legally, if the contract was subject to financing, I use that term globally, you're correct. But one can actually have a firm contract that has no subjects involved in it, and if they can't get the financing, it's their peril. They would then forfeit their deposit, which they indicate is significant or substantial. So what is challenging in your question is only in terms of what do the underlying contracts actually state. And that we do not know because we do not see those contracts. We just simply see the authorization for the applicant to act as agent. So what is there is based on the representations they provided in their communication that's before you as an appendix to the agenda today. So you have that. You can refer to that language. I think it's on the top of the second page.
I keep making final comments, Mr. Chair. The final comment, I know that 400 square foot place in Aldergrove, I know my $5,000 is gone. I've lost it. And I think I've lost it because I couldn't follow through. I mean, maybe you guys have different, down at the hall here, different rules, but that's the rule for a local citizen who's buying a place.
Okay, we're going to go into second speakers. Mayor Froese, you're the only one that didn't speak the first time, and then we're going to go into whoever puts their hand up. So, are you okay with that?
No, I'm fine with that. Thank you. I'm just interested in listening to the conversation and look forward to a motion to move this. Thanks.
The order's down as hands go up, so there's no nothing going on. So, Councilor Woodward, you're up.
Okay, so I'm going to try to help out here and try to focus the conversation. So, you know, but I did have one question, and I may have a couple of others as we go along here. You know, I just wanted to find out, you know, just some more information and more detail on the ALC decision, item 27, that the properties be dealt with together, and having one set of properties coming to us, not together with the others, combined with the request from the property owner of the other two that we table the matter until the ALC revisits that condition. Now, Mr. Beckett, can you give me some context for that in the sense that we have 8 lots, 2 different property owners, a condition from the ALC requiring that they be managed and dealt with together, but that not happening at the township?
Thank you, Mr. Chair. So to reiterate, from our perspective, the properties are being processed together as to the OCP amendment and the Metro Vancouver Growth Strategy amendment themselves. The rezoning applications we anticipate would likely be occurring concurrently, but they need not. It's really our level of involvement is at the higher level. Now, Mr. Seppi, perhaps you can interject in terms of how the application process was viewed by the staff that enabled it to get before us today, not today, at the bylaw for first and second reading stage, in terms of what their interpretation was.
Thank you, Mr. Beckett. Mr. Chair, I guess distinction that I would make is this: the exclusion application is not contingent upon the applicant proceeding with an OCP amendment. The exclusion application to the ALC stands on its own. And what they have highlighted, as Councilor Woodward referenced, are 5, as I recall, 5 conditions, which are actually connected to each other. Maybe actually you're talking about 3 conditions, one to do with the application proceeding together. What that means is the exclusion application, not any other application the owners might wish to proceed with the local government to change uses to other things, but simply speaking about the exclusion application for all 8 proceeding together. So what that means is, in technical terms, the owners would need to deal with, the applicants would need to deal with the land commission's conditions collectively, which comprise of a buffer along the northern boundary, which includes a fence, as well as a covenant that requires the owners to maintain that buffer in perpetuity. So those are connected. The other one we've talked about is stormwater management. That should happen for the entirety of the parcel or the parcels altogether. So those things can happen collectively as part of a single application through the OCP process. Again, the exclusion can still happen, whether it is together or not, as the applicant, as the Commonwealth application has made the application to the ALC for reconsideration. Whether the ALC decides that they wish to grant the separation or not doesn't really affect what's happening with us, because, as I said, one is not contingent upon the other. Exclusion can occur because they have technical, engineering, and maintenance and planning matters, as opposed to procedural that are outside of the ALC's jurisdiction and are really matters for the local government to deal with.
Okay, so I think that's very helpful. So what we're really dealing with here is there's that exclusion from the AOR, which has been accepted or confirmed subject to conditions, separate from our process. So if I could engage in a hypothetical, so let's assume, because it seems like it's pretty close to that it is 100% out of the ALR now, inside the rural plan. Would that be correct, Mr. Sefi? So if that comes out of the ALR, inside the rural plan, that would now be urban rural land for residential uses. Is that correct?
So hypothetically, Mr. Chair, if the land is excluded from land commission, assuming that or making the assumption that there are no conditions, now the land is removed. So now the land remains in the ALR, sorry, it's out of the ALR, but it's identified for rural. Maybe I can just share quickly my screen, because I do have some slides that.
Appreciate this. I think this is very important to try to clarify where I'm going with this.
Can you see my screen?
Yes, we can, yeah.
Excellent. So this is the subject area. And I think this is what Councillor Woodward's questions are relating to. So the land in the rural plan is identified as small farm country estates. So that will remain as such until such time as council decides what it wishes to do with it. So this is the ALR map showing the properties in the ALR. So assuming that they are excluded, they become white. The parcel properties will become white on this map, and then they will remain the heavy green on this map as small farm country estates in the township rural plan.
Okay, so can I continue? Is that a cue for me to continue?
Sounds like it.
Okay, so that would be I call it urban land because it's not in the ALR. I also refer to it as rural land because it's governed by the rural plan. Is that fair, Mr. Sepley?
That's fair, yes.
Yeah, okay. So then so I'm looking at it from a councillor point of view. The ALC's decided to do what they're going to do with the ALR. So now, if it comes out of the ALR, we have urban rural land, which is small farms, country estates. And then we are now left with a decision. Are we going to pursue and basically agree with expanding the urban boundary, modifying and expanding the Gloucester Community Plan, and redesignating and rezoning this land to industrial? That's our decision. That's how I frame it. We have urban rural land that is small farm country estates for residential uses, allowing certain amounts of subdivisions and lot sizes and so on. Similar to what we're currently looking at over there in the Timber Hills area, whatever it's called. So I don't view this as farmland to industrial. There's a step in the middle here that I think council is glossing over a bit. We have rural land, which is for residential uses as per our current community planning. And we're looking at a process to expand Gloucester, redesignate, and then rezone to industrial land that we planned for a long time to be small farms, country estates. And I don't think that should proceed, right away with a first and second on a rezoning. And I don't think that we should be converting residential land to industrial uses without looking at more carefully what infrastructure might be required to look at an expansion of Gloucester. And before I get to that second point, expansion of Gloucester and infrastructure and redesignation and rezoning of what is residential land. So Am I allowed to buy a townhouse site in Willoughby that is designated townhouses, pay high-rise rates for it, lots more money, and think, oh, I'm going to get a high-rise because I've overpaid for it, and then suddenly demand a high-rise, and then use what I paid for the land as justification for my high-rise? So for me, I'm looking at this as, if we're going to look at expanding the urban boundary, expanding the Gloucester area, and redesignating farm or country estate land into industrial uses, that is a significant increase in land value, potentially with some benefits to the municipality, but far more benefits to the private property owner. And I don't think it's appropriate to do that on a one-off first and second reading zoning, a rezoning of a couple of lots, just because they got out of the LR, great, let's make them industrial land. I think we need to be more realistic about what that actually means, what that actually looks like as a process. I'm very uncomfortable with that process. And I think it's very strange to me that private property owners would pay or claim to pay industrial land rates or something closer to industrial land rates, somehow assuming that we're going to do that. I don't know what that assumption is based on, other than that it's adjacent to Gloucester. I don't know where this assumption came from, that somehow we're going to pay millions per acre for country farm estate land and expect that we are entitled to a rezoning and an expansion of Gloucester. And so for me, if I'm going to support and look at expanding Gloucester, what does the municipality, the corporation and the taxpayer get from that? So yes, we do get some employment land, we get some jobs, but we also are required to contribute a significant amount of money for expanding the 264th interchange. We are required, as part of the long-term master transportation plan, we're looking at a 272nd overpass. The 264th interchange contribution, as far as I understand it, Mr. Beck can confirm, can't be added to the DCT program. That will be coming from property tax revenue. So why wouldn't a property owner that wants us to expand Gloucester and partner with us in expanding Gloucester at significant upside to them, sort of think, well, what is the municipality going to expect? What is the municipality going to benefit from this? And, and maybe a financial community benefit around infrastructure needs in the area makes sense. And, and maybe that discussion should occur prior to buying property. I mean, I just can't, and then now all of a sudden I've overpaid for land and now I'm entitled to a rezoning. I don't understand this process. I'll leave others to talk, but I have a couple of other thoughts around this, and that's where I'm coming from. I'm coming from an idea that we have infrastructure needs in the area. If we're going to expand the Gloucester Community Plan, I'm not looking at this as a land lift or a CAC program. I mean, that's what others are calling it. That's not my process. That's not what I'm calling it. Looking at infrastructure needs in the area and expansion of the Gloucester Community Plan and rezoning of parcels that are set aside for rural residential uses. We're now going to convert to industrial. And what is the process the municipality needs to go through in order to look at expanding Gloucester? And for me, at a minimum, that would be raising the issue of the 264th interchange contribution that it looks like we'll be required to make. And it would look like, well, the 272nd overpass in the long-term plan. These would be infrastructure items that I would begin to talk about. One of those, which can't be added to the DCT program, as I understand it. So, I mean, I think I'll raise those questions and wait for others to talk. But that's where I'm coming from. It's not this idea that somehow it's a land lift and we're bringing in policies that don't exist and this is unfair to property owners. I mean, that I think is misunderstanding the process of converting rural residential land to industrial uses and expanding Gloucester. And the process should be, I think, a bit more fair to the municipality than what I think I'm witnessing here, which is, oh, I overpaid for land and I deserve a rezoning. I don't understand that process. I don't understand why that's even coming up. It's not important to me who owns it. I don't really care who owns it. I don't care what they paid for it. I see rural land and someone wants to convert that to industrial and expand Gloucester. And I think that's the discussion we should be having. And what burden and impact does that place on the taxpayer down the road? when we rezone land or create more industrial land, we don't generate more property tax revenue from that unless the council will adjust mill rates, what this council wouldn't do. So we have to be careful that this idea that somehow we're benefiting from this. We don't receive income tax, we don't receive sales tax. So more jobs close to home is a great objective for a complete community, but that's not a financial benefit. And it doesn't help us pay for 264th interchange, doesn't help us pay for the 272nd interchange, which to me are going to be more needed if we start expanding Gloucester and converting our rural land and removing some of our rural character. We need to see, I think, more of a partnership on that than I think that this property owner has been offering so far. So that's where I have it. I have some other thoughts about motions to get down to some motions here about potentially considering the request of the second property owner to table this item until the ALC confirms reconsideration or not, and then looking at discussing with the proponent where this, and then some sort of community contribution benefit around expanding Gloucester, and giving some staff some leeway to begin those discussions based around the amount of money that's going to be required for 264th interchange, 272nd overpass, and looking at those items directly tied to the expansion of Gloucester. And I think that that's the discussion we need to be having, and give some time for that while the ALC considers their reconsideration. So I have some motions in mind, if anybody will entertain that, but I do not believe we should be rushing this first and second reading without discussing that. And I would also like to see a stormwater management plan be brought back into the discussion before first and second or before third. I'd like to get some idea of what that's going to look like. So I think some time here is warranted, and I think that that's the approach we should be taking, not this assumption that it's industrial land. Thank you.
Okay, before I go to the next speaker, there's an awful lot of questions in your comments, Councilor Woodward, and I was on council in 2008, so I don't know if staff can remember what direction council gave to those properties back then. If that might help answer your query as to who thinks this land is what. But also, I'd like to, I don't know, Mr. Sake, if you can answer this, but when you go to the ALC and make an application, do you not have to say what you're going to use the property for? And certainly, they wouldn't have said we're going to go there and build country estates. It's already zoned there. So that I don't know if maybe I'm going to confuse the issue by asking that question. But certainly back in the early 2000s, there was application made here, and if my memory serves me correctly, Councilor Rickey, you were there. I do believe we gave conditional approval to this as an expansion of Gloucester, so that could be part of the formula that gets us to where we are today. But anyway, Mr. Safi, you did have your hand up, and I hope you were taking notes of all that Councilor Woodward said. And before we go to Mayor Pros, did you want to respond? And it looks like you have a picture up there for us.
Thank you, Mr. Chair. I had my hand up because I had information about the ownership that was questioned, that was raised by Councillor Ferguson earlier on. It was brought to my attention that the ownership that existed at the time of the report that was received by council on May the 10th is actually in the council pack, in the CPC package, which is on page 25. That ownership remains unchanged today. And I just wanted to have the map in front of council at the same time as referencing that list that shows the 7 parties who are the owners. And as of today, staff has also confirmed that the 2 properties to the most east, portion along the east boundary of the block, those being 26713 56, as well as 5625 268, belong to a numbered company that is owned by Mr. Martini, Thomas Martini, as well as the other remaining 6 properties, 5 of which are under contract by Convest. The owners remain as shown on page 25, B1 of the CPC package, but Convest has an option to purchase with some conditions that we are not privy to. And in terms of your question, Councillor Rahman, Mr. Chair, I guess the history of the application, you are correct. Staff did have this slide just to share with council. It was back in 2008 when the application was made to the Township of Langley Council, because that is the process for applications to be to be processed by local governments before being referred to the Land Commission. And this is actually continuation of that process, if you will, because as you can see on the table here, the application was initially made in '08. It was referred by council based on ultimate use being compatible with the area to the east. That was referred to the ALC. It was rejected. The owners then requested reconsideration. The reconsideration was rejected. The owners then sought legal assistance, legal action, and then based on the legal action, the Land Commission was required to reconsider and arrive at the decision that is now being discussed by council.
Okay.
Point of information, Mr. Chair.
Really? Point of
Ferguson, point of information.
Caesar, what is your point?
Okay, my point of information, yeah, that Mr. Safety correct. I actually also have a copy of the BC land tax and survey for those properties, and I was able to get, that was actually part of something I dug out as well. So it's, I'm somewhat surprised by a couple of those things. That does make a difference on any decision I make. That's where I'm coming from, is that I imagine an applicant, any applicant can walk away at any time and lose their deposit. That's my understanding. It seemed to be, thank you, Mr. Safety, because it seemed to be, folks seem to be making it more complicated, but that's my understanding. They are not, this application are not on title. They are not the owners. The other person, Mr. Martini, he is the owner, so he's speaking up for his property rights. But anyway, thank you. I really appreciate that. Thank you.
Mayor Froze, you are up.
Thank you. So I appreciate all the comments that were made. It's been great discussion. I just want to add, I think there's one more step in the middle, just to clarify that because this is out of the urban containment boundary, it does require Metro Vancouver to approve the expansion of the urban containment boundary. So that's one more step. Mr. Seffi can confirm that when I'm done. I do agree. I don't think our decision making here is based on who paid what. I've had it's happened in over the last 10 years. Folks have shown up at my office saying, "Hey, I bought this land. I paid this much money. I need to have it up zoned so I can put," just like Councillor Woodward said, "I want a high rise now because it's only zoned for single family or townhouses." And I said, "Well, it's just too bad. You can have, you can take it to council, but it is what it is right now." And I have to give them my political viewpoint that it probably isn't going to be successful. So it's always at the risk of the purchaser. So I don't take that in consideration. I agree. That's something that for this council, well, for me anyway, I can't speak for everybody in council. They tell you that. That's great to know, but we have to make decisions based on what's good for the community and look at the application in front of us. We are short of industrial lands, and I think it's been brought up several times. There's always concern in the region about industrial lands, and it's difficult to grow land from other areas. It's not easy. It's we have lands in rural designations, residential, commercial, industrial. To find more, it's always at the give and take of something else. And I think I'm happy to be here to really consider this one. It is adjacent to established industrial area, but still we want to be careful what we do. The discussion on certainly amenities. There are costs that can be occurred, and when a motion comes forward, I'd be happy to see, number one, if we did table it or defer, but also to give staff instruction to work with the applicant and discuss the amenity to the township to address. I don't think we can ask one property owner to pay for everything, but certainly to address some of the concerns that have been raised by council, to ask for staff to work with the property owner. And on the other part about who owns it, I believe who's legally entitled to come to council is the person, is the entity that we deal with. Ownership, I might own something and I ask someone to represent me because I don't have the skills or the ability to do it myself, and I know that it's better. And I've done this years and years ago, maybe 40 years ago. A group of us got together, and I didn't know I had the expertise to go on my own, but as a group we went forward, and it got turned down, which is fine, but that was like 40 years ago. So I understand how property owners might want to be represented by somebody to make some contracts or whatever to help with that. So I don't have an issue with the ownership. I believe that this is legal. It's in front of us by a legally authorized proponent. So, and also the other next neighboring property owner with 2 properties certainly have their concerns, but I, and that this one be tabled. I think this one can be, we're still waiting for that ALC, or they're still waiting for that ALC decision. The council will then have to make those decisions, and yes, there's always a risk in land assemblies without firm zoning. They have to go through council, and we are, here to look after the best interests of the community as a whole. So, just my comments in that I don't see. Oh, and the other thing is the linkage. Mr. Sefi had mentioned earlier the nexus of the linking the funds to that if we are going to ask or negotiate have staff negotiate for additional funding, linking it to the needs of the community that they're going to go in. I think that's important, and certainly ALC has already identified that stormwater, water management is important, and certainly that can be done. And I know Councillor Woodward has mentioned there's certainly interchanges and road improvements that have to happen, and all that can be part of the negotiations. But myself, I don't have all that information, and I think a motion to refer this back to staff to work with the proponent and come back to council with some information. So those are my comments. And Mr. Sefi, just want to confirm there's that step of the Metro Vancouver process that has to occur. Thank you.
That is correct, Mr. Chair, through you to Mayor Froese, as has been referenced by Mr. Backen on a couple of occasions this morning. The application to amend the OCP, as the applicant has requested, to allow for anything other than, again, what was referenced, which is rural urban, was what Councillor Woodward referred to as small farm country estates. To amend the OCP to anything other than that requires Metro Vancouver approval as part of our process. Is not a standalone process. It's part of our process. If we choose not to proceed with the OCP amendment, that just goes away. If we decide that, if council decides that it wishes to give it up to 3 readings, that is something that has to happen before council considers the application for final reading.
Okay, so I have 2 hands up, Councillor Richter and Councillor Whitmarsh. Yours was first, Councillor Whitmarsh.
Okay, thank you. I just have a question through the chair to staff. Is there any information that would be helpful for us in terms of timing? This has come forward to council, but if we were to refer this to staff and take some more time to think through and have staff work with the proponent, is there some implications that we are unaware of that would be helpful for council to know by taking extra time?
Mr. Chair, staff is not, I guess, well, we are aware, but we don't know the details, and nor do we have the desire nor the information to confirm whether the information that's been shared with council is 100% accurate or not. What we are aware is that there are timelines that the proponent, the applicant, is obligated to I guess follow in terms of financial transactions that need to occur. As to the timing of when those are, staff is not aware. Typically, what we tell applicants is that a typical application process for rezoning takes approximately 12 to 18 months in the Council of Langley, based on council calendar, based on staff resources, based on our procedural requirements, between 12 to 18 months. That does not take into account an application that requires an OCP amendment, which triggers Metro Vancouver amendment. Clearly, that will then add to the 12 to 18 months by, I would guess, about 6 months, give or take. So ordinarily, at a very high end, I would suggest that the application would take between 1.5 years to 2 years to go through the process and get completion. And staff isn't aware of what that might do to the financial viability, nor the impact it might have on current contract discussions or status of contracts.
Right. Okay. So how far are we into the process so far? When you say 12 to 18 months or 18 to 24 months, Are we like 6 months into that time frame, or a year into that time frame? Where are we sort of sitting at here today?
Thank you again to you, Mr. Chair. The application's been made in December of last year. So if we can call that the beginning of the process, which is, I guess, again, arguably correct, because it takes about a couple of months for staff to actually sit down after the immediate referral to external and internal agencies. It takes us a couple of months to actually sit down and evaluate what's happening, what's been submitted. But, 6 months into it, essentially.
Okay, so that's helpful. Thank you for that information. Just some general comments from me. It seems to me that this land, since the 2008 application and then following through until 2017 when it was revisited by the ALC, that this land the intention was to always turn this land into industrial land and to have it as part of the expansion of Gloucester. And I, think we absolutely need more industrial land in our community. It does provide significant benefit for jobs, and more taxes are paid. And I understand the mill rate could be adjusted, but it does provide a significant benefit for us. So I certainly am in general supportive of that. I don't really see us turning it into 6 country estates right there on the edge of the Gloucester along the freeway. That doesn't seem like a real great place to build estate homes, but it does seem a good place for that for the expansion of industrial land that we so desperately need. However, I am also cognizant of some of the things that we need. We have some big expenses. I know we have the 264th interchange that's been mentioned by Councillor Woodward. I know that, that's not necessarily related to this. We're going to be doing it probably anyways, but they are big costs that we do have to incur. So I'm certainly fine from a time perspective of sending this referral back to staff to continue to work with the proponent and discuss some of the issues. I know it's not, we had a letter from them talking about CACs, and we're not talking about CACs here, but we are talking about significant infrastructure costs that relate to that area. And so I think it's good to have the question discussion, but I certainly am supportive of moving ahead at some point and seeing more industrial land. But I do want to have that conversation of how they can provide some more benefit to us in light of the benefits that they'll see as well. So again, not wanting to change rules in midstream, but I don't think we're necessarily doing that. So I think taking our time, it sounds like we're only 1/4 of the way in the timing. So we could have some extra time here to make sure we do our due diligence. So I would happy with referral. Thanks.
Thank you. And just before the next speaker, because we're talking about something that's got me confused. First of all, it already is small farm and country estates. It doesn't have to come out of the ALR to put a farm and a country estate there. It's right. I mean, that's a given. That's what it's zoned for right now. So there is no conversion happening. Just, the step. It's strictly going to go from the application from ALC to industrial. And then there was talk about revenues. Okay, maybe.
I'd like to raise a point of order, please. My hand has been up and I've been waiting for quite a while now. And your hand is not up, Councillor Long, so why are you interjecting comments at this stage?
Because I don't need to put the hand up to indicate that I want to speak. I'm speaking right now. Anyway, just to finish up.
Well, now, excuse me, you're one of 9 at this table. You're one of 9. You have the same rights to speak as the rest of us. Is there a speaking order? Don't you follow the speaking order?
My name is on the list. Anyway, just to finish up, then there is going to be considerable taxes from this property if it becomes industrial compared to what it is now. And what about DCCs? So if you don't want to hear the answer to that, that's fine. But I think that is also a factor. Isn't that correct, Mr. Backen? There would be different taxes coming from that property if it changes. And DCCs payable?
Thank you, Mr. Chair. The property, if it was reclassified or when it's reclassified, would certainly have a different tax regime. The issue of DCCs is a bit complicated, not to defer to Mr. Seffi, and the reason it's a bit complicated is ordinarily, yes, DCCs are payable, but historically, Gloucester was exempt from DCCs because they pre-serviced the area. I believe that these properties being outside of that area would be subject to DCCs, but I don't know if that means that the DCCs would actually flow to the township or under a previous agreement to one of the Gloucester entities that provided the servicing. Mr. Seppi, can you elaborate?
Yes, thank you, Mr. Backen. Mr. Chair, the DCCs would be payable because as Mr. Backen has correctly identified, the area is outside of the DCC exempt area. And yes, the DCCs would be payable to the Township of Langley and kept by the Township of Langley for use as part of DCC expenses.
Okay, thank you for that. Okay, Councilor Richter, you are up.
Thank you. On page 10, in the letter from Mr. Martini, I think there's a very clear statement made there that it seems somewhat premature to have this matter before council at this time prior to a decision from the ALC to vary the reasons to address only some of the properties and not all. It would seem more prudent for council to table this matter until a decision is reached by the ALC and all of the properties in the reasons to be dealt with together, as the ALC has consistently done throughout the property's history. Therefore, I am proposing a motion, and the motion I propose is that we defer further consideration of this application until reconsideration of the ALC conditions for exclusion has been completed. That's my motion.
I second that.
All right, now you're putting me in a spot here because we've had there's been several discussions of motions, so I don't know if we're prepared to have motions now. I guess I'll look to the group to see if that's what you wish to do. Or I had Councilor Ferguson on the speaker list. In fact, Councilor Richter, you were on the speaker list. I didn't know that you were going to pose a motion.
Well, it is 11:37. The meeting is over in 20 minutes. It's time to bring some sort of conclusions to bear. And so that's the motion I want to put forward for the group to deal with first. And I believe it's been seconded. So
okay, so we have more about allowing everyone to speak. So Councilor Ferguson and Councilor Woodward, are you okay with that? Or do you need to speak, Councilor Ferguson or Councilor?
I always like to speak, Chair, Deputy Mayor Long. I always like to say something of importance. If I may, do you have the floor?
Yeah, so what I'll do is I guess we'll take the motion right after Councilor Ferguson has spoken.
Okay, well, I'm sure they'll, I imagine there, Mr. Chair, there's also just housekeeping. We've always got the opportunity to extend the meeting, do we not?
Oh, yeah.
We're not bound by 12 o'clock, is that correct?
Of course, yeah, it's an important issue. It's up to the committee.
Okay, that's up to all the colleagues here. Okay, my question, I like asking simple questions today. Given this agricultural land commission exclusion, if they do get the necessary, these are all ifs, from the land commission, are they able to, through the chair, bypass Township of Langley and go directly to Metro Vancouver, if I may, through the chair?
Good question.
Mr. Seppi?
That is not how the system works, Mr. Chair. But I hesitate to be so definitive and say it cannot work like that because they do have the ability to consider an RGS amendment. It has to go through its own process, but I don't know that there is actually a mechanism that they have currently within their procedures that allows an applicant to bypass a municipality. That said, I guess anything is possible in theory.
Yeah,
Thank you.
You remember Councilor Ferguson being on the board. Back when I was on the board, I do believe that the sponsoring municipality brings forward the application. I think it's going to require a considerable majority before it can be passed.
Well, since we're looking at history, Councillor Long, I mean, I believe, maybe I get corrected by staff, I may not need it, when a person by the name Ainsley Loretto, who I never met, because I read it in a book somewhere. Oh, I read it in a report one time, applied for 640 acres to come out of the ALR for exclusion for the purpose of an industrial park. I believe there was a cabinet decision made by the government of the day to proceed with that, and I believe that the land commission had said no to it originally. So it was a cabinet decision by the provincial government at the time.
before the.
Given that history, 640 was seen to be enough at the time. I was surprised that this application did come forward, but here we are today. So there's still a little bit of history to look at. Thank you.
But that was before the regional strategy was established. Anyway,
Yeah,
we have a motion.
just a point of information. I'm pretty sure it would have to come through municipal sponsorship. I haven't, my history, I haven't seen any time where this sort of thing has gone to Metro without a municipal sponsorship.
If you need
I could be wrong.
7% of the vote, you better have your municipality to start with. So, Ms. Bauer, could you please tell me whether you have Councilor Richter's motion, because it has been moved by her, by Councilor Richter, and seconded by Councilor Woodward, and hopefully the rest of council okay that we've allowed that. Now we are open to motions. Do you have that motion, Ms. Bauer? And could you please read it?
Yes, Mr. Chair, I do. It was moved by Councilor Richter, seconded by Councilor Woodward, that the application be deferred for further consideration until after the reconsideration of the Agricultural Land Commission application to exclude the property from the Agricultural Land Reserve has concluded.
Okay, so that's motion's been made and seconded.
Well, that's not exactly the wording that I had, but
And could I get the correction, please?
yes, defer future consideration of this application until reconsideration of the ALC conditions for exclusion has been completed.
Okay, now I'm going to ask Mr. Bakken and Mr. Sefi to comment on that wording, because this is very complicated, and if that's the correct wording or acceptable wording.
Well, excuse me, Mr. Long, or Councillor Long, it's my motion. Do I not get to speak to it?
Well, there's no doubt you can speak to it. I've got a list, and I'm on it. By the way, I should let you know I'm on the list, and I see Councilor Woodward.
I don't see a hand up by your name.
I can't push the hand and run the meeting, so you can just take my word for it. But anyway, Mr. Bakken, did you have any comment about it?
That's the third time you've broken in on me when I have the floor. Okay, just saying.
Well, you just made a motion.
Yes, but I should have the right to discuss my motion.
You got to be first, you mean? You want to be first? Guess we could. All right, so Councilor Richter's going to speak first ahead of everybody else because she made the motion, but I want to make clear that Ms. Bauer got the motion and that the wording that had been corrected was appropriate. Mr. Bakken?
So I believe your question is directed to Ms. Bauer, but in context, I'm just interpreting the intent as to be a deferral till after the ALC proceedings have come to an end. The council deems that to be a material point in its decision-making process as to the ultimate disposition of this matter for first and second reading.
Okay, so Councilor Richter, you have the floor, and then I'm on.
Yes, I think that doing this right now, it allows the opportunity for clarification on what the ALC intent was. As I started to get into way back when the meeting first started, one of the questions that I have is, did we get our own legal opinion on whether or not we could process these in separate chunks? Or were we obligated to proceed according to the ALC's recommendation because they're of a higher order of government than we are? I also think that this has the potential to reach resolution. It's clear to me from the letters that were included in this package, and obviously both these letters are new to us. Well, there's three letters. There's one from Conwest, there's one from Martini, and there's one from Martini's lawyer, which is all new information that we did not get back in May when the application first landed on our desk, that there is some disagreement between the parties that needs to be resolved, and it would be clear to me that the parties need to resolve it with ALC. It will also give us the time to look at amenities that need to be addressed, such as the stormwater management plan. And staff did produce a very substantial report back a while ago in response to a motion from Councillor Arneson regarding the need to have a stormwater management plan. And at the time, we were told that there was a certain or a certain area that needed to be covered, and Gloucester, as it currently stood, did not meet that threshold. I also question Salmon River is not, I don't think the lands in that northwest quadrant that are being proposed to be removed feed into the Salmon River at all. I think it's all part of the same watershed, which is West Creek. So it seems to me that this allows time all the way around for a more robust discussion going forward on key aspects. I also appreciated the comments that the mayor raised with regards to asking staff to continue to work with the proponents, and perhaps that could be an amendment that's put into this. If the mayor wanted to put that amendment forward, I'm certainly supportive of dialogue continuing on. But essentially, we have a dispute here between two parties that needs to be resolved before I think we should be proceeding. So those are my reasons for this motion.
Thank you, Councilor Woodward. It makes total sense in many ways. Can I speak? No, Councilor Woodward, you are up next. Thank you.
Yeah, thanks for that, Councilor Long. I was just gonna give you a heads up that I have my own motion. I was gonna make my own motion, so I'd like to have a chance to do that when this one is disposed of, please.
Okay, well, is it going to be a complementary motion or a separate motion? I'm confused where we're heading here. So if it's different.
It didn't get to me before you took this motion, so I just want to let you know I have a motion ready to go. Thank you.
Okay, Councilor Ferguson. I wonder if we should.
Yeah, I just want to have an idea on this motion that, you know, we are moving forward with the letter sent, the two letters from Martini and letter from the applicant, understanding the fact that there's a contract and subject to, and they don't own the lands. That's not, I'm not asking for, but there's some information we need to know. And plus, as Councilor Richter said, what is the expectation on behalf of the ALC on what would be put there in the way of a land use? Anyway, that's, thank you.
Okay, I have Councilor Arneson.
Thank you, Mr. Chair. While I appreciate the intent of the motion, I won't be able to support it because I think one of the factual basis for me of this whole discussion today is it appears to me, and I agree with Councilor Richter entirely, that this is really at its heart, in some ways, a dispute amongst two property owners. But I don't get the sense personally, this is my perspective, that just deferring this until the ALC makes a decision is going to put those two different entities into a position where they are trying to remedy their own situation. So I think it's just going to extend the process, and I'm rather in favor of concurrently allowing the processes to go forward, which are actually quite lengthy, and to wait for the disposition. If the disposition is the Agricultural Land Commission will not look at the properties independent of each other, I don't know if they would or not, but if they don't do that, then we're going to be back to square one. I'm very supportive of staff working with the proponent to come up with some kind of contribution that seems reasonable under the circumstances, but I wouldn't understand why that can't happen, as I said, concurrently or in conjunction with these conversations, because I guess I'm troubled by the fact that it likely was that the parties knew or ought to have known there was a fundamental problem when we received the first application. Why didn't they raise the issue then? You know, I'm not pointing fingers to say somebody did something wrong, but if there was a challenge, it should have, I think, been more properly placed at the time when we first received it, and not piggybacking onto this meeting, which of course we can discuss the overall details of this application, but really it was meant, from my point of view, to talk about any kind of charges that we could put towards the rezoning of this property, and not to consider whether or not there was some confounding disagreement between the parties that should delay the matter. So I won't be able to support this. Thank you.
Hey, Councilor Davis.
Yes, thank you. I think that there are some merits to deferring it. However, it will it you know, it gives us time to look at transport, give a stormwater management plan, at what degree that plan will be from Mr. Ram and Steffi's comments. It'll get it's kind of I think it's putting the horse ahead of the cart, and the problem is I see that it will make more time in the end for the applicants, because but that we could still spend a bit of time and look at other things that we've talked about so I'm going to support it. It was a referral, wasn't it? Deferral, or was it a deferral?
Let's be clear. I think it was. Actually, Ms. Bauer, could you please read it?
No, it was a deferral.
But let's be clear on this.
Yeah. Okay.
Ms. Bauer?
In this instance, it would be a referral as it is being sent back to staff to await something. At this point, there is no motion on the table for first and second, so it would have to come forward for a new motion for first and second.
So it is a referral then. Sorry.
Yes.
Okay, thank you.
Staff to wait until a decision is made. Is that right?
That's right.
Okay. Councillor Woodward? Oh, you're on the mute there.
Of course I am, yeah. Yeah, I support it because I just think it's kind of a reasonable request from the other person. So if there's this idea that's been along in the beginning that these go together, and the ALC is going to reconsider that, I'd like to have that prior to it coming back. I mean, I think it also allows for some time for some discussions to occur, which will be the subject of my subsequent motion. So this bakes in some time, and I find the request from the other property owner to be reasonable. Their rationale was also pretty reasonable, unknown timelines and other considerations. So I don't view it as me trying to arbitrate a dispute. I view it as one property owner asking for something that I think we can give them, and I think we should be taking some time with this anyway. So that makes it easy for me to support this one. Thanks.
Excellent. Thank you. Mayor Froge, you're on.
Great. Thank you. Yeah, and I know Councillor Richter mentioned amendment. I'd prefer this motion. For myself, I'm not going to make an amendment to it. I prefer this motion to go on its own. The amendment can still, or not, a motion that perhaps Councillor Woodward will be coming forward with can still go on its own also, no matter what happens with this one. I do see this as two separate things, and nothing's going to happen until the ALC, comes through with their decision anyway. So I'm not going to support this because I think it's already inherent in what's happening. But I do understand the rationale. But I look forward to a future motion on. I think Council Woodward may be coming up with something. I don't know what it is, but something, and I would be coming up with a future motion to work with the proponents on some sort of contribution. So
yeah,
I'll leave it at that. Thanks.
Okay, Councilor Whitmarsh.
Yeah, just a quick question through the chair to staff. The timeline for the ALC making a decision on this 6 versus 8 properties, is there any sense of when that timeline would be or when we might expect a decision about that?
Mr. Seffi, based on past practice, any comment?
It's as clear as looking into a crystal ball.
Okay. So like could be in 2021, but maybe not. Is that what I'm hearing?
I apologize for my comment if it was somehow offensive. What I meant was that it's really very difficult, challenging to guesstimate because it could vary so significantly based on what are other priorities by the Land Commission and their meeting schedules.
Okay, thank you.
I wonder if I could speak just before Councilor Woodward then. I had a couple of questions. Would this decision by the ALC depend on what Council's position is? It could be a back and forth thing, for one. And number two was, if there's going to be a motion to perhaps negotiate with the proponent, which proponent would be only negotiating with Con West? How does the other two property owners fit into any negotiation? Although that isn't speaking to the motion, I suppose.
Mr. Seppi?
I'm sorry, was there a question for staff? In terms of the I guess the land commission awaiting a decision by the local government? No, as discussed earlier, this is purely a land commission decision that does not fetter council's ability to decide on a OCP amendment or rezoning or otherwise, and it's really a standalone decision. If that's the
Well, that was that's the answer. I wasn't seeking that answer, but that was the question I was asking. Although I'm still confused, because I always thought that the land commission would look at what the potential use is before it made its decision. So if it's not clear what the use is, I wonder if that changes the decision. Anyway, that's just a thought. Now, Councilor Woodward, you're back up.
Yeah, I just wanted to actually, I mean, I was a bit confused by Mayor Pro's, I just wanted to confirm, like, because if the rationale for not deferring, I thought we kind of needed to do this potentially, because it came to us prior to the ALC reconsideration process being complete. So I'm just looking for a clarification, because if there's time baked in anyway, then maybe I agree. But what I felt was that it came to us prior to while that reconsideration is going on. That's what I inferred from the Martini letter. So I was just wondering if that could be clarified for me, that's all.
Yes, thank you. Mr. Bakken? Or Mr. Sapien?
Or Mayor Froze even, if they could just get that clarified, yeah.
Anybody that knows the answer? Mayor Froze is disappeared there.
I'm struggling with my system here. Do you hear me?
You can hear.
There we go. Okay, yeah, I don't know. It's slowly push buttons and nothing happens. Here I am. No, maybe Mr. Seff can clarify. What I'm trying to say is that no matter what we do, we can pass first, second, third reading. Nothing's going to happen until the LC makes a decision. It's all contingent on that. So certainly that is baked in. However, I know that we don't with this motion passing, it would not go to first and second reading until it happens. So it's whatever goes first. We could do first and second. We could do third. It still has to get through the Agricultural Land Commission. We could do this first and second. It still has to go through the Agricultural Land Commission. That's all I'm saying. Council has that ability to do it either way. And so it is kind of baked in, but it is a different way of doing it. It is waiting for the decision, then they come back with the application. It goes through that process. I think the one proponent is asking just to do it concurrently, but really until they get that decision, it may be mute. They may come back and say, no, I'll have to come forward. So that's all I was trying to say.
Okay,
one more thing. I did look on the website. Metro Vancouver needs municipalities to come forward with OCP amendments, just for information. Thanks.
Okay, yeah, no, and I appreciate that. I'm just trying to get it clarified. So yeah, for me, might be a minor point. I'd like that ALC process to conclude completely before it comes forward for first and second. Of course, yeah, I could run concurrent, and I understand that, but I think that I'd like to get that process completely wrapped up. And I think that that's what I saw in the request from the other private property owner. And it seemed reasonable to me, so I still support it. But thank you, Mayor Frost, appreciate that.
So excuse me, Council, we're going to have to make a motion to extend the meeting.
I'll make that motion to 12:30, Mr. Chair.
I'll second the motion.
All right, any discussion? All in favor? Opposed? That's carried. Thank you. And so, Councilor Wood, you were still on. If you're done, then it's Councilor Richter again.
Yeah, I'm just not seeing the logical progression of us going through with a first and a second and a public hearing and a third. If the ALC can overturn everything, why would we waste staff's time? Why wouldn't we just say, okay, we're gonna wait for the ALC to make a decision on this? Because their decision is gonna impact us either way. I think this motion gives clear direction to staff to sit back and wait for the ALC decision.
Yes, okay. So, Mr. Bakken, could you please confirm, and Mr. Safey, that is the direction that this motion will give you, and that you would get it back, I guess, as soon as the decision's made, would it automatically just come back on the agenda, or what would happen?
Effectively, Mr. Chair, that's correct. As we understand the motion, it's been read a couple of times. It's to defer this to the ALC's decision. Once that decision is known, depending upon what that decision would be, I think it would automatically come back on the agenda as an item from a prior meeting.
All right, so let's ask the council, are you ready to vote? Anybody wish to speak? Council Rick, your hand's still up. Do you want to speak again?
No, thank you. I'll take my hand down.
Well, let's call the question then. All in favor?
Aye.
And opposed? Mayor Cruz and Council Arneson opposed. Then that's that. Now, did you still have a secondary motion, Councilor Woodward, that is still required now that we've passed that one?
Yeah, I would have another one that stands on its own along the lines of what Mayor Frozen and I have been discussing here at the meeting.
Okay.
So I have that ready to go, Mr. Chair, if you'll take that, and I will email it simultaneously to Ms. Bauer.
Okay.
I'll read that out for council's consideration. I'd like to move that staff hold substantive discussions with the proponents regarding community benefits to proceed with the expansion of Gloucester Industrial Park and the Township of Langley urban boundary and multiple community plan amendments. So moved.
I'll second.
Okay, and now you've got that in writing, Ms. Bauer or Mr. Bakken?
She'll have it in here in a very quick second. Yeah.
Excellent. Okay, let's have discussion on that then.
Well, just quickly, I think we've covered that in a lot of the previous discussion, Mr. Chair. I'd like to, authorize staff to hold these discussions along the lines we've discussed here. Maybe I can see if others have commentary, but I think it's in order to at least to hold these discussions based upon some of the requirements of infrastructure in the area. And to me, a pretty significant expansion of the urban boundary, multiple community plans, and removing a portion of rural character for industrial land. So I think it's important that these discussions be authorized by council with the support of council. Thank you.
Thank you. I have Councilor Ferguson and Councilor Davis.
Yeah, I just want to thank you. I just wanted to get some clarification on the motion. Does that include, if I may, regarding infrastructure and other challenges regarding building in the Gloucester area? That means whether it's road work, overpasses, whether it's stormwater management and other things that have to be part of that process. Is that, if I can ask Mr. Woodward, or I can get that clarification somehow?
Councilor Ferguson, I'll leave that to Mr. Backen to answer. Thank you.
Mr. Bakken?
There we go. Yes, the wording of the motion, I think, is broad enough that it can actually include many facets. So I think it would entail not only, some of the things you referenced, but also including the potential for financial. Again, not knowing how those conversations will go, I think it gives us a broad latitude to look at some options.
That was my question, and I thank you for that's a very good answer. The broadness is important, and I think it is indeed significant for us to get questions answered. This has actually been a very good meeting, Mr. Chair. We've got an awful lot, even though I don't think council or myself otherwise we're not opposed to industrial land or industrial parks. We just want to make sure we go through the appropriate process when adding new land to it. I think we've got several industrial parks in Langley, and they're doing well. And that was my only thing. Thank you.
Thank you, Councilor Ferguson. Councilor Davis, you're up.
Yes, thank you. I'll be brief. We're not going to turn into action. We're just going to talk. We're going to plan and maybe have some answers sitting on the table if and when this comes ahead, and then we can move on it at the time. So it's like I say, this gives us the flexibility to work at it, and we don't have to do any action. Well, we shouldn't do any action until we won't be able to because of the referral. But so I would support this. Thank you.
Councilor Davis, whatever machinery you're using, you're telling it loud and clear. So that's good. So whatever you do, keep that up. But the motion is actually to authorize staff to start negotiating right away. So
yeah. Thank you.
Councilor Arneson?
Yes, thank you, Mr. Chair. And I'm going to support this. I think it's a good idea to have staff to discuss with the proponent this novel and maybe potentially one-off situation we're going to see in our lifetime. I just want to make sure, though, for the public record, and I know staff is very attuned and, you know, thinking about all the considerations. I just want to make sure that any of the fees or benefit or whatever we want to call them, whatever name we want to attach to it, is fair and proportional relative to the actual size of the application. Because I would just like to remind council, the rest of the Gloucester Industrial Estates was negotiated on a situation in which, you know, there could be some concern that perhaps letting the last individuals in on this could get a disproportionate cost apportioned to them relative to what others have paid in the past. And just a reminder, the DCCs will be substantial. I'm not against infrastructure, and I know we have to expand these things, but I think it's most important that we consider what is the actual scope of this proposal relative to what else exists there, and the degree to which we want to burden this one application with all the things that perhaps should have been done by some other proponents in the past. Thank you.
Thank you. Councilor Whitmarsh?
Yeah, I was just going to indicate similar comments that Councilor Arneson has suggested. I certainly am supportive of this motion and having those conversations, but to use a sport analogy, I don't know if we want to try and go for a home run here necessarily and cover all of our bases that we missed in the previous times. But certainly there are costs that we have coming forward. This certainly is an expansion of industrial land, which is beneficial for us. And so I certainly support the conversations, but just to keep in mind that we want to be fair and honest in our approach. And I know staff would be doing that anyways, but I just wanted to support Councilor Arneson's comments.
Thank you. Councilor Woodward? What are you going to do with the meeting thing?
You did again, yeah. Add on to that, I think, you know, I don't want to start the negotiations saying, you know, ask for less. So I think that's kind of what I just heard. I think it's important that, you know, that we're not really placing a burden on people, and I don't view them as the last ones in, actually, because they're not inside the boundary. So I just felt the need to remind, you know, that we are adding on and expanding Gloucester, which I think can be argued has community benefit, but also significant private property benefit. And if we're going to be taking out rural land, or rural character land, or, you know, rural estate land and turning it into industrial land, that, you know, that we need to proceed carefully with that and look at what that looks like for the corporation, the municipality. And so, you know, that I would prefer that we, you know, these comments, unfortunately, you know, sometimes I hear from the staff that they take all comments of council seriously, and I appreciate that, but, you know, I think we should be careful, you know, already negotiating with ourselves, apparently. So I think we should just let the conversations occur and not start to already move backwards.
Thank you. So I have my hand up. I'd like to just ask a question. Staff, so when we talk about the road improvements required, that is right on the edge of the interchange. Would the provincial, would any improvements to the infrastructure, the road infrastructure, there be in our purview or the provincial governments, or would it be partnership? I don't know where the actual line is for beginning and ending of the you know, but right at that at 56 and 264th, there is an on-ramp to the freeway. There's an off-ramp of Highway 13. I don't know if Highway 13 terminates right at the freeway. If staff has any comment about what would have to be done and whose responsibility it might be in terms of those improvements, which are probably long overdue anyway. I don't know if you've ever sat there at 4:30 in the afternoon. It's a long way to get through that light. Probably should have a roundabout. But does staff have a comment that would help me in that respect?
Mr. Sefi.
Thank you, Mr. Chair. As council is aware, the current Highway 1 widening project does not include replacement of the existing 264 interchange. That is something that is in the works as part of the next phase. As staff currently understands, in discussions with the Ministry of Transportation staff to follow the next phase, which is through the 232nd interchange project. Now, that said, as I believe Councillor Long referenced, the improvements that are needed at 264 go beyond this particular project and this particular, I guess, exclusion application. They are needed regardless, and it would be a matter of further discussion as to the end of jurisdiction of the municipal boundary and the beginning of the provincial jurisdiction. That is something that is not set in stone, and it's subject to further discussions as to the exact configuration of a future interchange and where the access and egress points might be, following certain rules, technical guidelines, but at this point, not able to anticipate.
But Mr. Safety, that intersection of 56 and 264, is there something in the long-term transportation plan that calls for a roundabout or anything of that nature there? Or is what you're saying it's sort of not on the table because
concepts have been discussed. There is a concept that shows an overpass of Highway 1 with 56th Avenue that might reduce the impact and the volume of traffic at the interchange itself. So those are matters that have been discussed, as I said, regardless of this application.
Okay, thank you. Any further discussion? So the motion has been discussed. Is there any more discussion on it? Or can we call the vote? Okay, seeing none, we'll call the vote. All in favor?
Aye.
And opposed? It's a unanimous consent. Look at that. Well done. All right, so that's the end of that motion. Do you have another one, Councilor Richter?
Yes, I do. I'd like to put forward a motion that council asks staff to begin work on and to bring forward for council consideration an amendment to existing policies or a new policy regarding community benefits from, or community benefit contributions from future commercial and industrial lands. And I will send that motion to Ms. Bauer.
All right, so you're asking the committee to discuss that and then be forward to council, or would you,
Well, if it's a recommendation from this committee, it has to go back to full council for final approval. But
Okay.
basically it's saying that we should be looking at, I know we've got community amenity contributions from residential. Maybe we should be looking at having community benefit contributions from commercial and industrial lands, because they've been excluded up to this point. We may need a separate category, or perhaps staff is able to fit it into the existing policy. I don't know, but I think I would like them to start work on it.
Okay, is there a second? Because I did hear Mr. Safety say earlier that he's looking into this policy anyway, but let's see where we are. Do we need a seconder? We do. Councilor Davis seconds. So I'll ask right away, before you've already had an explanation, Councilor, you certainly have the floor still, but I mean, Mr. Safety, you did say earlier that you have a program update for us, hopefully by the summer, that is going to look at OCP amendments and non-residential uses of lands in terms of community benefit contributions rather than amenities now. So perhaps you could comment on my behalf, not on behalf for me, Mr. Safety, if this is what you're already doing, and therefore this motion would be supportive of that.
Thank you, Mr. Chair. Yes, I did say earlier that staff has been engaged or has engaged a consultant, a third-party consultant, and currently anticipates being able to respond or present council with their findings and options and some recommendations that deal with non-residential contributions prior to the summer break, prior to August. So one of the July meetings, that is what we're currently aiming for, to make that presentation to council.
Thank you. So, Mr. Bakken, I would like to ask if this motion is going to interrupt, cause concern, or support that work that Mr. Safety says. clarified. That would make a difference on my vote.
Thank you, Mr. Chair. As I recall, the motion that the project that Mr. Seppi is working on stems from previous council motion. We don't know if Ms. Bauer has that handy for her, but that might help because then we could actually examine if it's complementary. I believe it's fundamentally complementary, but I'm not sure what the original motion was. So if we take a moment, we can have Ms. Bauer pull that up.
Okay, while you're doing that, we'll have Councilor Davis speak, if that's okay.
No, I'm sorry. I guess I didn't take my hand down. I just,
Oh, okay.
yeah, sorry.
Okay, so staff is see if this is complementary to a previous motion, which I can't recall, but there must have been some. And procedurally, does it make much difference? It has to come back to council anyway. I wonder if this might slow it down. Mayor Froese, would you like to speak while we're looking? Oh, you're on the mute. There you go. And then I go Ferguson. Go ahead, Mayor Froese. Oh, there you
Okay.
go.
Oh, there we go. Okay. Yeah, this is a referral to council anyway. So at that point, I think staff could come back with that information and maybe just allow us this really at this stage doesn't have any
Yeah.
traction. So
Ferguson? Sorry, Mayor Froese, you finished?
yeah, that's all I want to point out. It's if we want more information, and then that comes if Council Richter still wants to proceed. Thanks.
Councilor Ferguson, your comments.
Yeah, if I just wanted to clarify from staff, is this piggybacking on, which is good, on something that might already be in process with the staff? I know we did discuss something about getting information regarding extra density and other applications that are not within our purview and policy. If I may, through the chair, is this a piggyback of that?
Mr. Bakken, Mr. Sapie?
I think
Yes.
it may, but Ms. Bauer, are you out there? We haven't heard from you, so it's making sure you're actually looking something up.
Good afternoon, Mr. Backen. Yes, I am trying to look it up. Unfortunately, given the words in the motions, they come up quite frequently in the minutes. It's a little bit longer to narrow it down than I'd like.
Okay, well, as Mayor Froese has pointed out, this is a recommendation to council. Staff will have, we don't want to put staff on the spot that we're doing. I mean, there'll be time for research coming forward before it comes to council. So if that makes it more comfortable to call the vote.
No, I just wanted to point out, Mr. Chair, is the fact that, if there's something ongoing as well, they could work together and that would speed up the process. I know the other one regarding density, but they work together and they might indeed be able to mesh with some help to move it forward. Thank you.
Mr. Sapie already made comment when I asked about the project that you're underway. It didn't mention density. I thought it was talking about non-residential properties and OCP amendments. Does that, I guess it may include density in some respect in the general term, but would you care to comment there, Mr. Sapie?
Thank you, Mr. Chair. What I said earlier was that staff is working to respond to two directions from council, while Ms. Bauer is looking at finding the exact wording of those two resolutions that staff is hoping to respond to council back on prior to the August break. What I said was that one related, generally speaking, to applications that trigger an OCP amendment. What I do have in my records, which may not be the final way that the council resolution ends up being, is that council directs staff to investigate options for providing the necessary target contributions, fees, charges, etc., for requests for extra density for residential and commercial developments and report back to council. Now, this was in the context of OCP amendments. And what was the date of that? I don't have the date. So there are two things. One is applications that drive an OCP amendment, and there are applications that are not residential. So any non-residential application, staff is hoping to report back to council on.
Good, okay, well, I don't see any harm in this motion because it's gonna come back to council anyway, and it does allow staff to do some more, research, and we could have a much better motion when it hits council. So, Councilor Rick, your hand is still up?
Yes. Yeah, I just wanted to say in reference to the mayor's comments, I believe it's complimentary. And it's just, from my perspective, giving staff additional direction from council that we want to see this done and that it's important to us to get it done. So if it can come to us by the end of July, great news. And if it can't, well, at least they know we'd like to see it on their work plan going forward.
Okay, any further discussion? Let's call the question on the motion then. Ready? All in favor?
Aye.
Opposed? That carries unanimously. All right, any other business, council, or we could adjourn 8 minutes early? Although it's 22 minutes late. Okay, motion to terminate. Who's gonna do that?
Termination.
Oh,
I can-
works too, yeah. And second by Councilor, Mayor Froese. All in favor? Opposed? Thank you, Council, for your patience. And,
Yeah, thank you, Council Long.
have a
Good, everyone. Good day.
Take care, everyone.
Have a good day, everyone.